A very good afternoon to one and all present here. I, Bhavya, feel extremely honored to welcome our Honorable Chancellor Sir, Professor Gurdip Singh Bahri, to have an interactive session with all of us. On behalf of IMS Unison University, I extend my heartiest welcome to Sir, Deans and Heads of all departments, faculty members, and all the attendees. We are honored to have amongst us a very knowledgeable and inspiring personality, Professor Gurdip Singh Bahri, Chancellor, IMS Unison University. Sir is here to guide us on the topic handling Ukraine-Russia Federation crisis, the response of International Court of Justice. Sir, we are extremely honored by your presence and request you to please enlighten us with your precious knowledge. Can we please have a huge round of applause for our Honorable Chancellor, sir?
My dearest students, very distinguished colleagues, Professor Amit Adlakha, the officiating Dean of School of Law, Professor Madhu Prabhakaran, the Dean, School of Liberal Arts, my colleagues from School of Liberal Arts, School of Law, very good afternoon to all of you. As a matter of fact, I'm delighted to be here with you because today happens to be a very special day for all of us. It is World Water Day. And the theme of 22nd March 2022 World Water Day is underground water, making invisible visible. In the morning, even our Prime Minister, during his address, took a promise from all people of India to make a pledge to conserve even one drop of water. And you already understand, it's not topic of the day, but we all know how relevant the underground water is for agriculture, for industry, for sanitation. And including COVID has brought water into prominence due to hand washing and hygiene frequently. My dearest friends, we have all passed through very difficult stages. As a matter of fact, the mankind has been in trouble first due to coronavirus, spread almost all over the world. Its variants which came out by way of mutation of the virus from time to time. And even now, the fourth wave is knocking our doors. Most of the cities in China have been locked out due to the spread of Delta Cron, which is dangerous, unlike Omicron. And to add to human tragedies, we have before us the present Russian Federation crisis, which is threatening to turn into a full-fledged world war. Fierce force is being used during Russian Federation's military operations in Ukraine. We are all aware about it. We are all aware about the bombing and shelling of not only military targets, but even the civilian population. We are deeply involved into all this. But the point remains how this crisis has to be handled. As legal scholars, as scholars of liberal art, we must understand how International Court of Justice is handling the crisis, how other international bodies are handling the crisis. The military operations began on 24th of February this year. On 26th February, Ukraine filed an application in the International Court of Justice, alleging the commission of genocide, a grave crime in international law, a crime against humanity, war crime, posing threat to mankind as such. But then, after Ukraine filed an application on 26th of February in the International Court of Justice, requesting the court to give provisional measures in the form of some provisional directions to Russian Federation, pending the case for decision on merits. Decision on merits takes time. On 5th of March, Russian Federation communicated to the court through its ambassadors to other countries that Russian Federation would not participate in the proceedings before International Court of Justice. Because, according to Russian Federation, International Court of Justice did not have the jurisdiction to try the case. Very interesting fact here. Whenever jurisdiction of the International Court of Justice is in dispute, the court has to first decide whether it has the jurisdiction over the dispute or not. Then comes the issue of provisional measures and the decision on merits. International Court of Justice, in fact, the main chairman, Judge Donogil, told Russian Federation, stated very expressly that it is the duty of these concerned states to appear before the court for sound administration of justice. Now, this is not the first time that a disputing state refused to participate in the proceedings. It happened before also. United States also did the same thing. You know, I was a doctoral fellow at the Hague International Court of Justice. That was the time of 1984 onwards. There were military activities of United States inside and around Nicaragua. Nicaragua filed a case in the International Court of Justice. You know, we witnessed ourselves at The Hague in the International Court of Justice. US delegation gate crashing the room of the judges of International Court of Justice and warning the judges that court being without jurisdiction United States would not appear in proceedings before the court. And the threat was not hollow. Proceedings started. US did not appear. Nevertheless, in 1986, the court delivered a judgment deciding against, obviously, United States and directing United States to pay reparations to Nicaragua. Look at the tragedy. The judgment still lies unimplemented. Why? We will come to the enforcement of the judgment slightly later, and I will tell you why the judgment is still unimplemented, despite the direction for reparations to Nicaragua way back in 1986. We will take up that matter slightly later. Now, coming back to this controversy. Soviet Russia communicated to the court indirectly. Directly, it did not participate. Indirectly, that Soviet Russia used force in the form of military operations in Nicaragua under Article 51 of United Nations Charter in self-defense. How? Look, very interesting arguments of Russian Federation. Russian Federation clarified that Ukraine was engaged in genocide against Russian ethnic groups in Donetsk and Luhansk. And United States treated both these Ukrainian territories as independent republics, calling them as Donetsk People's Republic and Luhansk People's Republic. Now, the Ukrainian government intended to eliminate, by way of mass killing, the Russian ethnic groups residing in these two eastern regions of Ukraine. These two, according to Russia, being independent states, forcibly occupied by Ukraine. And therefore, to stop genocide by Ukrainian government, Russia used force. We all know that United Nations Charter is world constitution to maintain international peace and security. We all know that the very preamble talks about the peoples of United Nations determined to save the succeeding generations from scourge of war. Here is complete violation of the preamble. Look at the purposes of UN Charter, look at the principles. Article 2, paragraph 4 of the UN Charter is frequently quoted everywhere. You read the newspapers, you will find it time and again. Under 2.4, use of force is prohibited against territorial integrity of a state or political independence of a state, or in any other manner inconsistent with the purposes of the United Nations. But use of force here means economic force and armed force, all types of force. There is no absolute prohibition. Look, use of force still remains lawful. Under Chapter 7 of the Charter by the UN Security Council, political organ, and under Article 51, in individual or collective self-defense. There is no complete ban, absolute ban on use of force. Russian contention is that it used armed force under 51 to save the Russian ethnic groups from genocide. Ukraine, on the other hand, as you all know, treated the Russian invasion of Ukraine by way of military operations as violation of Genocide Convention of 1948. It's a very old convention. Treating genocide as international crime. Crime against the world as such. And the International Court of Justice first decided that the dispute really occurred between the two countries, Ukraine and Russian Federation. It is as regard commission of genocide. There is one Article 9 of the Genocide Convention, according to which any state party can approach International Court of Justice to prevent the commission of genocide. For the purposes of prevention and punishment for genocide, any state party can approach International Court of Justice. Ukraine found the jurisdiction of the court on the basis of Article 9. Both Ukraine and Russia are parties to Genocide Convention. Earlier they made reservations. Later on, the reservations of both the countries were disputed and both the countries withdrew their respective reservations to Geneva Convention. Presently, both Ukraine and Russian Federation accept the jurisdiction of the court in case of genocide in unreserved manner without any reservation whatsoever. So, ICJ had a very ticklish problem before it. It can grant the relief in the form of provisional measures only when the provisional measures are intended to avoid irreparable damage, irreparable loss to life or property. Number one. Number two, there is pressing urgency for the purposes of provisional measures. And the provisional measures must be related to the relief sought for on merits. ICJ had no difficulty in deciding that there was a threat of irreparable prejudice, irreparable damage, irreparable prejudice to the relief sought for prevention and commission of genocide. Therefore, ICJ decided to announce provisional measures in the case under Article 41 of the Statute of International Court of Justice, wherein International Court of Justice has the power to deliver provisional measures to prevent the likelihood of irreparable damage in cases of urgency. Now, the jurisdiction of ICJ was found on the basis of Article 9 of Genocide Convention and, look, Article 36, Paragraph 1 of the Statute of International Court of Justice. All states can refer a matter to the court by way of their express consent, or in case a matter is provided in the UN Charter or any treaty or convention in force. Here, both the states did not agree. US did not agree to the jurisdiction. USA, it remained out. USSR remained out. Russian Federation remained out. Ukraine filed an application. On the basis of 36(1), matter specially provided for in the convention, Genocide Convention. Article 9. ICJ had no difficulty in holding that it had the jurisdiction and announced provisional measures. ICJ, in fact, referred to earlier cases wherein it had pronounced provisional measures. Law Grant's case of 2001, wherein United States was also a party. Then later, military activities near Nicaragua was obviously referred to, and in addition, ICJ referred to the latest judgment of 2020 in Gambia versus Myanmar's case, where in 2020, the case was regarding interpretation, application, and fulfillment of Genocide Convention, the same convention. And the ICJ, in that Myanmar's case, announced provisional measures. ICJ also clarified that provisional measures of International Court of Justice were legally binding on the states. Legally binding. It has been decided by ICJ not only in this case while delivering provisional measures, but in other cases. Nicaragua, Law Grant, and latest interpretation, application, and fulfillment of Geneva Convention, Myanmar's case. It is not the first time that Russian Federation had designs of annexation of the territory. Earlier, in 2014, Russian Federation annexed even Crimea. We all know that. I'm not referring to it. But the fact remains, on 16th of March, just 2 days before your holy celebration, ICJ directed the Russian Federation to immediately suspend the military operations in Nicaragua, especially the operations against civilian population, because civilians are also being targeted. Number one, Nicaragua prayed to the court that the court should also direct Russian Federation to submit a report within 1 week of the order regarding compliance with the orders of the court. And at regular intervals thereafter as fixed by International Court of Justice. International Court of Justice did not heed to that request and never directed Russian Federation to submit the compliance report within 1 week as alleged by Ukraine. And at regular intervals fixed by ICJ thereafter. That request was not heeded to. But then this verdict was delivered by way of majority of 13 votes to 2. You know there are 15 judges of the court. 13 decided in favor, 2 decided against. You know who decided against? Russian judge, Georgian, who was also the vice president of the court, and Chinese judge, Xu. Both Russian and Chinese judges voted against. Our Indian judge, Justice Dalveer Bhandari, also supported the majority of judgment. Despite the stance by his nominating country, India. You know, this is the second term of Justice Dalveer Bhandari, our very good friend at International Court of Justice. Earlier, when I was there in the court, Dr. Nagendra Singh used to be judge of the court, and he rose to the position of the president of the court also later. Anyhow, those were very interesting days, which I always recall and cherish. But now Dalveer Bhandari, our good friend, Judge Saab was very senior, very, very senior, Dr. Nagendra Singh. But Dalveer Bhandari belongs to our age group, not that senior. In 2012, he was first elected. The term is 9 years. But after every 3 years, the judges are elected by way of rotation. In 2018, it so happened that there was one vacancy. Indian government nominated Dalveer Bhandari. UK government nominated Christopher Greenwood. This selection is by way of General Assembly and Security Council simultaneously. In General Assembly, Dalveer Bhandari won by massive majority. In the Security Council, United Kingdom judge nominated Christopher Greenwood won. But later on, UK withdrew the name of Christopher Greenwood, and Dalveer Bhandari was elevated as judge of the court for the second time. India had to lobby a lot for him. You know why? The case of Kulbhushan Jadhav was pending in the court that time. He was convicted by Pakistan of espionage. And in 2018, Dalveer Bhandari got re-elected. In July 2019, ICJ gave a verdict in that Kulbhushan Jadhav's case, directing Pakistani government to review and reconsider Jadhav's espionage sentence and grant consular access to him. All that happened thereafter. You know, the purpose for intensive lobbying by Indian government at that time. Now, on provisional measures, 13-2 majority, verdict delivered. This is the handling by International Court of Justice. You will obviously ask me, sir, Russia has refused to comply with the provisional measures. It is still using massive force in Ukrainian territory. How to enforce the judgment of the court? It is unfortunate that in international law we have enforcement problems. The decision of the court is purely legal till made. But when it comes to enforcement, it is transformed into political matter. Under Article 94, paragraph 2 of the UN Charter, if judgment debtor state fails to comply with the order of the court, judgment creditor state can have recourse to the Security Council. And thereafter what happens? Listen to the wording. I'm giving you the exact wording of 94.2. Thereafter the Security Council may, not shall, may, if it deems necessary, make recommendations or give effect to the judgment of the court. It is not bound to. It may, if it deems necessary. The matter is absolutely political. Now, the interesting story is, look at how other bodies reacted. Last month only, United Nations moved the UN Security Council, requesting the Council to pass a resolution directing Russian Federation to stop military operations immediately. Well, Russian Federation, being a permanent member, enjoying the privilege, exercised veto power. Three members, Asian members of UN Security Council, India, China, and United Arab Emirates, UAE. These three members abstained. And UN Security Council was not able to pass a resolution because of the veto of Soviet Russia. All the three Asian members of the Security Council abstained. Look at the situation. The matter came before the General Assembly. You know, if the Security Council fails to discharge its responsibility, then at international level, General Assembly steps into the shoes of the Security Council. On 2nd March, the matter was considered by the General Assembly. In the General Assembly also, India abstained. Ultimately, resolution was passed. Many countries abstained. There were as many as 35 abstentions. By way of 141 to 35 abstentions, General Assembly passed a resolution. Very dilute resolution, requesting Russian Federation to suspend the military operations. On 5th of March, again, look, another human rights body based in Geneva. You know, there is no more Human Rights Commission now. It has been succeeded by UN Human Rights Council with headquarters at Geneva. The matter pending before Human Rights Council was in March, especially 5th of March, whether Human Rights Council should establish an international commission of inquiry to go and monitor the matter of special military operations by Russian Federation in Ukraine. India again abstained, even in Human Rights Council. Obviously, for political reasons. We all know now, this is the story. And then one more body at Geneva, ICRC, International Committee of Red Cross, which is the only body having authority to monitor human rights violations, grave violations of human rights, and to monitor the condition, the plight of civilian persons who suffer from human rights violations. You know, at Geneva, I was UN fellow at Geneva, but then for some time I worked at ICRC also, delivered lectures on international humanitarian. ICRC could not do much because of opposition by many members of ICRC. That is how the situation is being handled by International Court of Justice and international bodies. If you look at now international humanitarian law, hardly I have the time to take you inside the international humanitarian law and human rights law. But there is gross violation. If you look at international humanitarian law, I will sum up by bringing to your notice that international humanitarian law attempts to balance, it's a triangle in fact. It tends to balance the three mandates. One corner of the triangle is held by humanitarian considerations. The second corner is held by military necessity. The third corner is held by principle of proportionality. You know, if there is, in cases of extreme necessity to use force, all principles of proportionality have to be taken into account. And it must be ensured that civilians are not made the target. Only the belligerents, the combatants are made the targets. You know the 4 Geneva Conventions and 3 protocols now. Not merely the 2 protocols of 1977, 3 protocols, one more on distinctive emblem. This is a new protocol which has come up. All doctors, ambulances, they must carry, earlier they were required to carry the symbol of Red Cross. No, not Red Cross, but red crystal. You know why? There were opposition by Mohammedan groups. That Red Cross belongs to, it's a Christian sign. So there was opposition. Amidst opposition, of late came additional protocol on distinctive emblem. And the workers, volunteers, helping civilians by way of medical services had to carry the emblem of red crystal. You know, happen koi? Nahi. It's a red crystal. Yeah. Nahi. It's having 4 corners, red corners 4, red crystal, and white in the center. That is the distinctive emblem now. Doctors, ambulances not to be attacked, civilians not to be attacked. Force used has to be proportionate. You know, there are various principles. And the foundation is humanitarian principles, humanity, necessity, neutrality, and impartiality. I have given you only 4. These are the basic principles of the whole international humanitarian law. The fact remains, the threat is, imminent threat now is that Russia is planning to use first biological and chemical weapons. That is US calculation. And you know what is Russia's response? Russia says United States has biological and chemical laboratory in Ukraine. And they are holding us guilty. This is one. And you all must have known through the news that United States has placed anti-ballistic and ballistic missiles in the form of Patriots. Just 16 kilometers away, Poland's border. You know, these are comparatively very light, having the range of just 100 kilometers. These can be fired from the land and destroy the enemy's missile while it is in trajectory. On its way, before it hits the target, it can be destroyed. You know, this is not the latest. The range of American anti-ballistic missiles now runs in about 15,000 to 20,000 kilometers. But this is the first step taken by US. Even the range of our Agni, Indian Agni anti-ballistic missile is about 5,600 kilometers now. We have reached Agni 4 stage. You know, all this is strategic international law. I have given you strategic international law, international relations, handling of the crisis by ICJ and international bodies. And absolutely no doubt that human rights law and humanitarian law is human rights applicable in armed conflict. Human rights law is applicable during peace as well as armed conflict, both. So both humanitarian law and human rights law is applicable in case of Ukraine. One last word from my side before you get bored. UN Secretary General Antonio has made it very clear, very express, that mankind, it is high time for the mankind to embrace peace, sustainable development, and human rights. And for the purpose, 2030 agenda for sustainable development should be the guiding compass for the mankind. I started with the greetings today. World Water Day. You know, if you look at goal 6, there are 17 goals, sustainable development goals of 2030 agenda. And the 6th goal is conservation of water. Right in 1993, UN General Assembly decided to celebrate 22nd March as World Water Day. And the themes every year are different. Water is connected with climate change, which is troubling mankind everywhere, with energy, agriculture, everything. Without water, life is meaningless. I started with that. Now I'm hinting at interlinks between peace, sustainable development, and human rights. These are integrally linked with each other. And this is the high time for the mankind to embrace and be guided by the compass of Agenda 2030, which talks about everything, peace, security, everything. Fine. Well, I'm not giving you the recommendations from my side, but it's a food for thought for you. So far, General Assembly has not passed Uniting for Peace resolution. Russia has been a party to Council of Europe. Council of Europe has not taken any action so far, as far as conflict is concerned. But the consolation is, Council for Europe has expelled Russian Federation from the Council. That is only the consolation. But then, the crisis remains, and it has yet to be handled. And let me add a final word for your information, that in case General Assembly of the United Nations passes Uniting for Peace resolution, it is not legally binding. It is only recommendatory in character. Right? So where lies the problem in international scenario? The problem lies when it comes to the enforcement. Whether it is international law, whether it is International Court of Justice, other organizations, the enforcement, implementation of international peace and security becomes a political matter. And we feel perhaps international law has failed. Perhaps international organizations have failed in handling the crisis. But the crux of the problem is the weakness lies in enforcement part. And states are sovereign, as you know. No central political authority above the states. So there are inherent problems which we have to deal with. Not that there is no international law. International law, International Court of Justice, international bodies are dealing with the crisis. Even International Criminal Court is dealing with the crisis. Let me bring to your notice, neither Ukraine nor Russia is a party to the Rome Statute for the establishment of International Criminal Court, which is functioning from 2002 onwards. India is also not a party because we have our own reservations, which we made clear. I'm not going into that, but I only want to bring to your notice that the court has jurisdiction over crimes against humanity, war crimes, genocide, and crime of aggression. 4 categories. A state can refer, a state party to the statute of the court can refer a matter to the court. But here is the crisis which Ukraine referred to ICC. And the prosecutor of International Criminal Court has taken cognizance, investigated the matter. But for proceeding further, the authorization of pre-trial chamber of International Criminal Court is required, which is not yet obtained. So, all the international bodies, judicial bodies, criminal court, International Criminal Court is also situated at The Hague. When I was doctoral fellow, there was no International Criminal Court. It is established much, much later and functioning from 2002 onwards. But the fact remains, even ICC, International Criminal Court, is not behind. It has also taken cognizance of the matter by way of public prosecutor investigating. But then the further trial remains. That is the international scenario. Food for thought for you. Think from your side and come out with your own suggestions as to how the crisis should be ideally handled at the international level, keeping in mind the existing enforcement problems in international law. Thank you very much for your patience. I hope this is enough food of thought for you. Any questions you can raise? As I told you, it has to be participative. I have given you the information. But if you have any specific questions, specific query, you are most welcome. Hanji, please stand up. Speak loudly.
Sir, today's Security Council is an impaired organ. It has been unable to act with credibility, essentially due to its unrepresentative nature. Without United Nations Security Council reform, will United Nations lose credibility? So what is your opinion on this?
Yes. Good. It's a good question. He is advocating the reforms in the UN Security Council. It's not a new issue. It has been raised earlier also. Even India is demanding the reforms in the UN Security Council. Either you dilute the veto power of the permanent members or make it more representative. Let me bring to your notice that we, India, has been claiming a permanent status in the Security Council. We do not enjoy permanent status, we have a non-permanent status, non-permanent member we are. Various reforms have been suggested in the past. But the fact remains, the heart of the matter is that one or the other permanent member is not willing to carry out the suggested reforms because they enjoy the special status, veto. Sometimes, this is let me tell you now, crux of the matter. This is not a war between Ukraine and Russian Federation. The gist is, the heart of the matter is, it's a war between United States and Russian Federation. Ukraine is being sandwiched. All NATO countries have been warned by the Russian Federation that any NATO member who comes ahead and helps Ukraine, he would be treated at war with Russian Federation. That is the warning to all NATO states. There was a time when Ukraine had Russian orientation. With the change in president, the scenario in Ukraine changed. Now there is US domination in Ukraine governance. The scenario has been changing from time to time. The NATO countries are not actively helping. You have heard Zelensky today openly accusing NATO for remaining away from the conflict. Ukraine's membership to NATO was pending at one time. Now NATO is against admission of Ukraine. For one reason or the other, states are not coming out openly. NATO states, they are backing out. Even India is receiving oil from Soviet Russia, Russian Federation. Even now we are receiving oil. We are receiving it. So we are abstaining. But when it comes to the stand by the judge of International Court of Justice, a judge discharges judicial functions independently of the stance of nominating state. This is what Justice Dalveer Bhandari did, despite India's abstention everywhere. Justice Dalveer Bhandari went with the majority. But the point is very validly raised. Reforms, drastic reforms are required in the enforcement mechanisms. And the enforcement body, unfortunately, is the political body, Security Council. So the first step is reforms in the Security Council itself, which is called for. Very right. Sakshi.
In the same thread, I would like to pose this question. If we are clearly able to see that all this politics, which is causing the problems in enforcement of international law, can be attributed to the structure of Security Is there a catch-22 kind of a situation that in order to change the structure, we need to get the Security Council on board and then we can...
You need to get the Security Council in the picture. Because as I told you, even Uniting for Peace resolution is not legally binding. It is only recommendatory. You know, even if we have Uniting for Peace, we should have, even if we have it in the crisis, it will only be a recommendation, not legally binding for the states. So restructuring of the Security Council is need of the hour, need of the time. That's true. Now, before I bore the students and colleagues anymore and deprive them of their well-deserved lunch, I thank you all for being present. Thank you.